Good evening, Crime Talk aficionados. This is Scott Reisch of Crime Talk. Thanks for tuning in. This is our Tuesday night live event. For those of you who do not know or have not followed us before, my name is Scott Reisch. I am a practicing criminal defense attorney here in the state of Colorado, and we started this channel a couple of years ago because we were so frustrated by what was presented on the news and what was not presented on the news. And frankly, what it boiled down to is the people that were on the news talking about criminal cases knew absolutely nothing about what they were talking about. So we started this channel out of frustration, and I checked minutes before we came on the air, and I believe we are now officially, hold on, let's see, 136,000 subscribers. So thank you all very, very much. That is rather humbling because at one point I said, you know, if I could get maybe 5, 10, maybe 25,000 subscribers, I'd be really happy and satisfied. So the fact that you all have helped us get now to over 136,000 subscribers is greatly, greatly appreciated. And we obviously could not do it without you. We appreciate everything that you guys do, and particularly taking your time, energy, and resources to come here and listen to what we have to say. We try not to disappoint, and hopefully that will be the case after tonight as well. You won't be disappointed. So as always, there is plenty to talk about in the world of criminal law. It never gets boring. There's always something new to talk about, and literally you cannot make these facts up. People with the greatest imagination out there couldn't make these facts up that we get to talk about, that brings us together in this true crime genre. I mean, it is a passion for lots and lots of people. This is what I do on a daily basis. It never gets old. Some days, I'm going to admit it, I get a little tired, need to recharge those batteries, but it never gets old. So I know you all like it. Like I said, the true crime genre as it relates to cold cases, current cases in the news. But hopefully what we do is we bring some effective news, facts, and analysis. And I always like it when I do a program and I get people from both sides of the case telling me that I'm a sellout, I'm a hack. It's obvious that I'm for the defendant. It's obvious that, well, guess what? If I'm offending everybody, or I wouldn't say offending everybody, but if I'm getting other people to think that I'm not being fair to both sides, apparently we're laying the facts out there. Because frankly, it is what it is. You know, if there's one thing I've learned about an attorney, and a lot of people, you know, think attorneys can be heartless and, you know, it doesn't really matter. You just get paid to do what you can for your client. And that's what lawyers are trained to do. We're to look at the facts, and a good lawyer could argue both sides of any case. I mean, honestly, I mean, whether I was, you know, a prosecutor or a defense attorney, I could get to make, you know, an argument for both sides. That's what a good lawyer does. A good lawyer does not ignore the facts. And that's the thing. I don't know if it bugs you, but you see some of these people on TV, they pick a side and they're never, ever, ever going to change their mind because they picked their side, regardless of the facts. They just ignore the facts. And I've said this before, and I've tried to explain it to lots and lots of people. As an attorney, your job is to look at the facts. We have to tell our clients the good, the bad, and the ugly about their case so that they can make the best decision about that. And because they're the ones that ultimately decide, geez, if I plead guilty or go to trial and I lose, am I going to go to prison for the rest of my life? Am I going to go to prison for a couple of years? How is this going to affect my family, my career? So you have to literally be thinking about everything. How is this going to play to a bunch of average jurors? Average citizens who are picked for a jury case. It is you have to look at all the facts. Bottom line, you cannot ignore anything that comes up. And that's what we try to do here, is take a look at it. So that's who I am. That's what I do. Like I said, we've handled literally just about every type of criminal case over the last 25 years. So we have a pretty good idea of way things are going to work out and the way they're going to go. Now, today we talked about on our show that we put up today about the Daybell-Vallow case, and her attorney has filed a motion to transfer as well as a motion to join her trial. And you have to kind of look close at this, but this is the original case. This was the case that started out regarding the desertion of the children. And then ultimately the felony charges were dismissed, and those were misdemeanors. So Mr. Means, the attorney for Daybell-Vallow in this particular case, filed two motions yesterday. And one was the motion for transfer. And he states that pursuant to the rules, the 6th and 14th Amendments, and Articles 1 and 7 of the Idaho State Constitution, it says, it shall be supported by the papers and pleadings, in this case, the memorandum of law to be filed, evidence to be submitted, and the evidence to be adduced at the hearings of this motion. He requests that both parties be allowed to brief this issue as it relates to that issue. Frankly, I think that motion is insufficient. That does nothing. Basically saying, Judge, I'm putting a motion out here, not supported by facts in any way. Basically saying he's not going to get a fair trial. But then more importantly, he says he wants to join the misdemeanor case as it relates to the felony case. And he says it's based upon the same facts, series of facts, charges against the defendant, and the exact same facts alleged in the Fremont County District Court case CR 22-20-0838, which is a felony case. Now, I can tell you as a criminal defense attorney, when you take your case in front of a jury, you would prefer to have the least number of charges possible. Okay? And the reason being is, and I've had cases where I've had like 52 counts. Okay? I would much rather have a 1 or 2 count complaint information before the jury, because it's just easier, right? If you got 52 counts, or in this case, you've got the multiple counts of destruction of the body, and then you want to bring in the remaining counts of the obstruction and inducing somebody to lie to police, things like that. Yes, they come out of the same facts, but guess what? Who cares? Why would you make it easy for the prosecution to present their case only once? I just don't get that. Okay? Ladies and gentlemen, sometimes as a criminal defense attorney, you have a duty to not always get along with the district attorney. Sometimes you have to say, hey man, I know you're a decent guy, but guess what? You're being completely unreasonable. So we waive nothing. The only thing that we waive is the American flag. Dun, 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 dun. That's it. And you want to bring in your evidence? Don't ask for any stipulations. You are trying to send my client to prison? Yeah, guess what? Game on. And this Mark Means guy, I do not understand what he's doing. And I hate, I don't like to, it's always when you are critical of another attorney, particularly of a case that you're not on, and he may know facts that we don't know. But from what I've seen, this guy has just made a blunder at every move. He failed miserably at the bond reduction hearing. The first one, obviously, the bond got reduced from $5 million to $1 million. I think that was actually before his participation in the case, and his previous Daybell-Vallow's previous attorneys got off. Then, he filed this motion for bond reduction because he somehow thought that there were communications that were listened to by sheriff deputies, and therefore that would be a basis for a bond reduction. Like, are you kidding me? And it was a waste of time. And the judge said it was all but a waste of time when he did those motions as well. And obviously they were denied. He waived the preliminary hearing. I guess that was the good fact, because frankly, if there was a way to mess it up at this point, he probably would have done that. Maybe Mark Pryor told him, don't ask a single question. And I should, just let him do his thing, so to speak. Because Mark, I'm just not impressed. And then to say, yeah, let's just make it easy on the government. We'll just file a motion to move the case and join it with the other case. Well, guess what? Another reason why Chad Daybell is going to ask through his attorney, Mr. Pryor, for there to be severance, because there's going to be obviously more charges coming in, evidence coming in against Lori Vallow that will not be admissible against him. And the other thing is the prosecutor is the one that wanted to join the cases between Chad and Lori. Once again, as a criminal defense attorney, you may want that. You may know that's absolutely going to happen, but you have to object, and you have to go in there and say, Judge, this is going to be unfair. Judge, you're creating error. This is going to get reversed if you do this. So let's not do it again twice. Let's do separate trials. I'll take my own chances with my client, and I don't need to be there with her attorney. But frankly, it seems as though Mr. Means wants to be with Mr. Pryor for trial and kind of ride his coattails. It's probably the best thing that he could have possibly done at this point. You see that new mug? Look at that. They just arrived. Look at that bad boy. New mug. We like it. We're perfecting this stuff. So anyway, so let me think about what, let me know what you think about this. Leave us a comment. Obviously there's lots of people here. The comments are coming through. It's I don't know. I don't get it. And maybe, let's see, Kathy Griffith said, your disdain is obvious. I just don't get it. It's just an amateur move. And I've seen that on a case. Okay. And we've all been young attorneys. We've all been there like, oh, which way do I go? And that's why you listen to people much smarter than you, people that have done this type of stuff for years. Everybody thinks they can be a lawyer. I get that. Frankly, anybody can go to law school and you can Google it. But what you're paying for when you hire an attorney is their years of experience, those years of cases where maybe he didn't know which way he was going, but he learned from it. Because let's face it, you always learn from your mistakes more than your victories. And I literally learned something new at every trial. And this year is clearly going to be an exception because of COVID, but we were on a roll, January, February doing trials. And then obviously everything came to an end. And I'm still not sure what the hell is going on. The federal court here just extended their moratorium on jury trials here in Denver. But yet I've got a case that may fall into their pilot case because we're in front of the chief judge. I don't know what's going on. It is just a crazy world out there. I don't know if, do we wear masks? Can everyone be okay? I don't know, but the criminal defense world needs to get back to normal when it comes to jury trials. And, I think it's what did we do? Did we shut everything down for cold and flu season? No, we didn't. We used common sense, right? Common sense. Hey, if you're sick, don't be around people that you haven't infected yet. Send your disease elsewhere and we'll disinfect the area. We have somebody shows up to us sick at the office. We think they had the flu. Go home. What are you doing here? Disinfect your space before you go. It's just common sense. We cannot not have trials forever. Hey, Scott, does Lori have a case of ineffective assistance of counsel? Does she not have the option to fire him now? Otto Yoda. So ineffective assistance of counsel, that is the claim that is made once you go to trial, you lose, and you lose on appeal. Then you have to use your post-conviction relief argument saying that somebody was in fact ineffective. That's where that would come from, so to speak. You can't, not really going to really make that argument now. Has he done anything up to this point that's been, I mean, you just kind of cringe every time he opens his mouth. But maybe that's just me. Maybe he just rubbed me the wrong way based upon what I saw of his performance, and it relates to the motion for bond award. Terry Dalton, do you think that she would win an appeal for insufficient or ineffective assistance counsel? Terry, no, not at this point. No. And when you do ineffective assistance of counsel, that's really everybody armchair quarterbacking everything. And it's tough because not only do you have to show that the attorney's performance level fell below that of basically a competent attorney, and a competent attorney, he can fog a mirror. That's a legal standard. The Strickland case, which is the United States Supreme Court case, which sets the standard for effective assistance of counsel. There have been cases where people have been doing death penalty cases and they have fallen asleep, and that is effective assistance of counsel. The question is do they do something that they did or failed to do something that was so outrageous, so bad that no other attorney would have done it, and it could have changed the result. That's really what it amounts to. Is there anything so far? No, because frankly, I think Pryor has helped him out thus far. He hasn't been able to do any real harm. I mean, he's kept his client in custody. He's made some motions that were borderline frivolous. Maybe he's a little gun shy. He knows the world is watching. He doesn't want to get out there and screw it up again. So we'll have to just wait and see. Angie, it's more contagious than the flu, and you can have it and not know it. I get that. I understand that, Angie, but at some point we have to get back to normal. The world, the economy, the judicial system cannot sit here and wait for the coronavirus to go away. People are in custody. They have constitutional rights. And I have looked in my pocket version of the Constitution, and nowhere is there a pandemic exclusion in the Constitution anywhere. And frankly, I haven't seen any exceptions in the Constitution to your constitutional rights because of a pandemic. And some of the courts are starting to recognize that. There's been some challenges to things where, churches haven't been able to congregate. I mean, being able to practice your religion is a fundamental right. Freedom of protest under the First Amendment, constitutional right. That's okay, but you can't go to church, which is another constitutional right. There was a court last week, I think it was in Pennsylvania, if I'm correct, read the opinion and basically said, hey, this does not go on indefinitely, and you cannot have these restrictions on fundamental rights indefinitely. And having your right to a jury trial, that is not something that's insignificant. The cases must go on. Dolores, will they be charged with murder? I've said this before, and I'll say it again. At this point, I don't see it happening. I do not see it happening unless until somebody wants to come forward or talks. And I just don't see that happening short of some sort of confession or cooperation agreement. I don't think they're going to be charged with murder. So, yeah. Let's see. Mark Means, he's a divorce and custody attorney. This is Tammy Flo. He has no business representing Lori at this stage. She's going for ineffective assistance of counsel. She may, just like I talked about where, sometimes you object to motions, you file things. You have good faith basis for it. You have to do that as a lawyer, have a good faith basis for it. Well, he certainly has a good faith basis to object to all these joinder motions. And yet He's just confessing them. It may be good strategy, but I think it's a better strategy to know that it's coming, and then you still get the objection. It's on the record for that. So it just doesn't make sense. You have to think. It's not just thinking like everybody else. It's not thinking like a civil attorney. Okay, and I've done civil work. I have attorneys that work for me that do civil work, and it's a little more straightforward. With the defense stuff, it's more nuanced. You really have to, civil stuff, you try to stay a step or two ahead. That's all you need to, because it frankly just moves so slow, and frankly, it is what it is. But on the criminal side, that's where you have to think 5 steps ahead where this stuff is going. Let's see, Rebecca, question here. Have you ever seen a judge encourage a lawyer to do their job? No, I mean, I think most attorneys, if you don't think you can effectively represent somebody, you should get off their case. So let's see. Let's see here. As being charged with murder, look at Casey Anthony. No proof of murder. I believe Casey Anthony was charged. She's a little girl found in, I think she was charged with the murder of her child, but obviously she was found guilty. Let's see here. Pixie dust. I like that. And I went to the merchandise and I cannot find the black one. I think that's referring to the mug. I think it should be there. Or the lawyer mug as well. I think that's still there. Frank, the hardest working man in show business, is going to check it out. I believe they're all still there. Scott, do you think it will come out that another family member was involved? I don't know. I just don't see it. I mean, the prosecutor in the case, Mr. Wood, he seems like a nice enough guy. Very methodical, very check the box, made all his elements, so to speak. He just doesn't seem particularly excited about this case one way or the other. Maybe it's just me. I mean, I don't know the man. I've only seen him on TV. But he doesn't seem, he's not out there kind of showboating. He's very methodical. Seems like a very good guy, probably a career prosecutor. But I don't see that he's necessarily going over the top, to go over it. I don't know. Jen, super chat here. And, we appreciate super chats, never required, but greatly appreciated, particularly when we have lots of questions flying by here. Scott, how much damning evidence do you think the cops are holding back on the Daybells? Example, phone records. P.S. Where's Tammy's autopsy? Good question. Where's the autopsy? Come on. All right. I've said this before. If they wanted something to get done, they being the government wanted something to get done, it would get done. All right. Think about all the government investigations that are ongoing, and we can't release any information because the investigation is ongoing. Really think about it. We've all watched 48 Hours, and the first 48, where the homicide takes place and they go and find somebody, they find the suspects, they go and they try to do what they can. They know the first 48 hours are the most critical. People solve murders. They solve lots and lots of crimes rather quickly. And yet some of these investigations go on and on and on. So it truly makes you believe that they obviously don't have enough evidence, because if they did have enough evidence by now, they would have charged it. I frankly think that there is not that much damning evidence as it relates to Lori and Chad that we're somehow going to get sprung on us at trial. I think the juicy stuff was in the affidavit for the arrest warrants for both. I think the preliminary hearing We got the highlights of it. I think there's going to be a lot of methodical stuff, but once again, these phone records going back and forth, you have to be able to show, okay, that may be the records, but prove that they're the ones that had the phone on that particular day. Is the phone registered in their name? Did somebody else have access to it? All these conversations or text messages with Alex Cox, the brother, those there. How's that coming into evidence? That's a hearsay statement by someone who is not available for cross-examination, obviously, because he's dead. And he'd have his own Fifth Amendment issues if he was going to do that as well. Obviously, if he was still alive. I don't know. I think we have seen the evidence, and I hope I'm wrong. I really hope that I'm wrong. I hope that there is something that the government has, some smoking gun that they're maybe just holding back. But I don't think so. Like I said, I hope I'm wrong, but I don't think that that's ultimately going to be the case, just because. Yep. All right. The lovely Miss Kristen fact checked it. Casey Anthony was not guilty. 2011, July 15th, the jury found Casey not guilty of first-degree murder, aggravated child abuse, and aggravated manslaughter of a child. Yeah, I remember that case. It was 2000. I mean, what's his name? His attorney, her attorney. Smart guys won some big cases down there. It got off the Weinstein case. Why can't I think of his name off the top of my head? Exhaustion. Can the governor, state of Missouri, or the senator remove a family court judge of Clay County, Missouri? Gina Weiss, good question. Can a governor, state of Missouri, or the senator, or the Senate, or remove a family court judge of Clay County, Missouri? Not usually. Now, I'm not going to say I am an expert on Missouri state law, but most judges, whether they're elected or appointed, are usually there until the next election or some sort of retention process goes, unless, of course, they've committed some sort of a crime. Just because somebody doesn't like the decision of a judge doesn't mean that they just simply get removed. You have to remember, it's litigation, ladies and gentlemen. It's litigation. There's always going to be an unhappy party. Nobody goes into litigation most people don't come out happy one way or the other. Usually the only people that come out happy in litigation are the attorneys. But normally, judges can't be removed. People can say, "Oh, we don't like the judge. He or she should not be retained in the future." But unless they've committed some sort of official misconduct, don't get me wrong. There's lots of judges that I've had over the years not agree with me, so to speak. And I don't, run off and say they need to be kicked off the bench. I may say they're incompetent. I may say they don't get it. But it doesn't necessarily mean they're there. Hey, guess what, ladies and gentlemen? You're in some states, judges are elected by the people, which I think is just kind of weird. We have a retention process here, but they're appointed by our public officials. And some of them you just think, oh my gosh, this must be a political payback. Why are we going to have some person who has never even tried a case somehow be a judge at the trial court level? It just doesn't make sense, and people are appointed judges for lots of reasons. We'll just have to see. Sorry, not an expert on the state of Missouri laws as it relates to family court judges, but just because you don't like a decision doesn't mean you get to kick them out unless it's illegal. I mean, if they commit misconduct, they can be impeached. So there you go. All right, Janine Lewis, I love that Chad's attorney said there was no credible evidence against his client. Well, has he heard the voicemail with Lori and seen the dark and light letter plus all the phone pings? Good try. Well, Janine, you have to remember he is the lawyer for Chad Daybell. Of course, he's going to say, there's no credible evidence. My client is being wrongfully accused. He's going to beat the desk, cite the law, let the world know that this is a travesty of a mockery of a sham, that his client is being prosecuted for these charges. And that's what he's paid to do. You have to remember, ladies and gentlemen, these attorneys are advocates, right? They're advocates. They're there to say, yes, we have bad facts, but we're going to highlight our good facts. Yes, does he have something to work with in this particular case? You betcha he does. You bet he has something to work with, referring to Chad Daybell. I mean, seriously, you got good. I mean, just go back to some of the questions, and you can watch the preliminary hearings. We put up both days of the preliminary hearings as it relates to Chad Daybell, and they're linked below. I think they're in the series, or what do we not the series, what do we call it? The, where we have all the stuff related to Daybell-Vallow. And it's all there. You can see, I mean, there's lots of questions. I mean, the bottom line is they have to prove knowledge. They have to prove that those individuals knew that the bodies were there and that they were going to be dug up. Now, that phone call where Daybell-Vallow calls from the jail and Chad says, yeah, they're here, they're digging on the property, and you kind of hear like, oh, okay. And it's not what was said, what wasn't said. But to their credit, at least they didn't say, oh my God, they're going to go out and dig up, the remains of JJ and Ty Lee. So, but it's not what was said, what wasn't said, and the way it was not said in that particular phone call, because it's not a good call. It's not a good call for Lori or Chad, to be all honest with you. But the good facts that Chad has is say, okay, fine. When did those bodies get buried there? Who did it? We know there's homes right across the street, that we've talked about, a memorial out, that's on the house fence. The house across the street on the fence there's a memorial. And the older brother of Lori and JJ did a memorial to them and wrote a note. And we talked about it the other day. So the question then, when did it happen? Where? I mean, did these neighbors not notice anybody out there digging, even in the middle of the night? I mean, let's face it, you get up and you get yourself a glass of water or, whatever, you're probably going to see some activity on that property in the middle of the night. Nobody saw it. When did it get there? Obviously it did. They dug it up there. But did anybody see it? Was there some star witness that they're holding back? I don't think so. We'll just have to wait and see. But, the prosecutor can't even answer the questions of how did the children die? Who killed them? Why? When did they get placed there? I mean, they can say, well, we think during this particular time frame, but think about it, ladies and gentlemen. If you're a juror and the defense attorney gets up and says, ladies and gentlemen, closing statement, and says, we asked all these witnesses, the FBI, some of the smartest people in the business, and they cannot tell you who put those bodies there. When did they get placed there? How did those children die? Well, guess what, ladies and gentlemen? If the prosecutor can't tell you that, and if the prosecutor doesn't know that, how do they expect you to know that? And guess what, ladies and gentlemen? That's reasonable doubt. We talked about the example we gave the other day. Knowledge in any criminal case, you have to be able to show that it was done knowingly. The example I gave, you get pulled over in your car, your kids were driving your car. Cops say, hey, pulled you over for maybe simple speeding or something. But it's weird because my dog is just happens to be a drug trained dog. Mind if he walks around your car and it hits and they find drugs in the back seat? They can say, well, it's your car. You're responsible for what's there. You obviously knew these drugs were there. And you're like, I have no idea that those are drugs. They had no idea. They were pushed in the car seat, down low. How would I have known they were there? Well, ma'am, sir, it's your car. You're responsible for it. Well, guess what? The law recognizes that's not the case. Just because it's there on your property doesn't mean that you had knowledge of what was going on. And if they can't answer those questions or have proof of beyond a reasonable doubt, which is the highest form of proof known in the law, ladies and gentlemen, how are they going to be able to prove that case? It's going to be very, very interesting. It's going to be very interesting. And I hope the prosecutor has some new evidence out there. I just don't think it's, I don't know. I just don't think it's particularly overwhelming evidence at this point, just because I just don't think it's actually super overwhelming. Yes, there's lots of things to me need to be explained. Do I think that Daybell-Vallow had some explaining to do? You betcha. Do I think that she did not act as a missing mother would? Absolutely. But guess what? As soon as the state charged her with a criminal case, her constitutional rights, they attach. And now she no longer has to prove herself innocent. She simply has to make the government say, prove it, prove it. So that's just the way it is. You know, people may not like it, but I'm just telling you the way I think it is. You know, at the end of the day, will they get a conviction? Maybe, probably. We'll just have to wait and see. Jurors are smart people. We shouldn't criticize jurors' decisions because they're making the best decision they can with the information they have and following the law that was given to them. They probably need, they may not necessarily agree with the law, but they have to follow it. And jurors take their jobs very, very seriously. So let's see here. Now, I've had a couple people ask about this. Mrs. Zim, Mr. Scott, were you able to voice your opinion on the Sophie Long case since it's making noise all over social media? One case, that's the custody battle case. Wants to stay with her dad, but the court's basically not doing that. Let me tell you, I would rather, child custody cases are some of the worst cases around. And although I don't have the statistics right in front of me right now, I think if there were false allegations of abuse, whether physical or of a sexual nature, usually come from divorce cases, child custody battles, because that's how bad it gets for the other people to get the other side back or to get them back, to get the child back. So I think that's one case I'm going to stay miles and miles away from because I don't know all the facts. Divorce cases are the worst. They're the worst. DD, stage 3 lockdown, Victoria, Australia. Sorry about that. That's unfortunate. Let's see here. I don't understand. Dana White, UFC handled perfectly. Let that be a model for other businesses. Oh, probably on the COVID. We have to adapt. I think that's all we have to do. We can't just sit in our basements and hope that it's going to go away. We need to get out there, adapt, wash your hands, wear your mask if that's what they think is going to do it. I just think it's always weird. First was don't wear a mask because you don't know how to wear a mask, so you're probably going to infect more people. But then it was now you need to wear a mask. I don't care what it is, but wear something on your face. or just stay away from the people. But I think the biggest people that need to stay and be careful are the people that are over 70, have underlying issues that could cause them to have some real bad issues. I've known a couple people, family members that have gotten the old COVID and a couple of days of discomfort, and they were okay, thank goodness. Now, obviously, some people are going to get sick and some people are going to die, but that's, it's unfortunate, but that happens in life. And the people that are at higher risk should take greater precautions than those obviously don't have as much risk. So, Emmy Means is primarily divorce and custody attorney. I agree. But, everybody thinks they could be a criminal defense attorney. It's all it takes. Read a little bit about it, listen to a couple of podcasts. Everybody's a criminal defense attorney, right? It's all it takes. I wish it were that easy. I've learned some hard lessons over the years, ladies and gentlemen. And I'm telling you, it's not the same as doing a civil case. It's just different. There's so many things that go into it, so much more different things that go into defending a criminal case, even prosecuting a criminal case than a civil case. Civil case, you're talking about money, right? At the end of the day, okay, it's money. You can go make more. You can do whatever. But criminal case, you're talking about dealing with somebody's liberty. That's why prosecutors have such a great responsibility with the positions that they hold, because they are talking about an allegation can ruin somebody's life, their livelihood, their employment, take away their liberty. So they got to be certain that they've got enough to prove the case. Okay, it is what it is. I don't believe that Mr. Means was charged with anything recently. No. I believe Mr. Pryor had a case. He went to trial. It was a misdemeanor case, but it sounds like it was ended up being more of a harassment. It's been a while since I've looked at that. But hey, the man still has his law license. You think he would know better not to put himself into precarious situations, but that's sometimes we all do that. KB03 Psalms. How in the heck no murder charges come and 2 dead children? Hopefully you listen to what I had to say about they have to prove knowledge. I mean, they have to prove that somebody did it, not just hunch and suspicion. I mean, what if you woke up in the morning and you had a dead animal that's laying on your property? Did you do something to that animal? Somebody drive by and throw it in there? It's they have to prove that you did it. What about conspiracy to commit murder? Will they be charged with that? Patricia, once again, who's a conspiracy with? Alex Cox. I mean, obviously they charged a conspiracy as it relates to the delay and the hindrance of discovery of the evidence. And they're going based upon, text messages, which is going to be interesting. But they have to be, you have to be able to show you have an agreement between 2 or more people to commit an illegal act. That is a conspiracy. Sometimes you can have unindicted co-conspirators. You can have conspirators that are now dead, but you could only introduce those statements in as if they are in furtherance of the conspiracy. Not everything you say comes in at that point. It gets very complicated. And, one of the things the defense should say is like, hey, you're charging a conspiracy. We want you to submit a proffer of what statements are coming in, said by whom, to be introduced by which witness, under what rule of evidence are they coming in. I mean, that's the time you really start making the government put their money where their mouth is and say, hey, you charge a conspiracy, bring it on. You show me what's being being brought in. I've seen that particularly in lots of big drug cases. Like, okay, you think you have a conspiracy? Let's do it. Let's do it. Let's see here. Let's see. Yeah. Let's see here. Yeah, maybe they were actually killed in a different county. Absolutely. See, I've seen judges zip attorneys up before those being cross-examined answered. That's true. We've all had that. It's good attorney. You keep going until somebody objects or the judge shuts you down. Long case. What do you think about this case? Yeah, Ms. Zim. Yeah, I'm not. Child custody cases. Bad. Not going there. Sympathetic to all those situations, but my experience is when it comes to divorce cases and child custody issues, neither party comes with clean hands. All right, and that's a legal doctrine that if you're seeking relief, particularly used to be when you had courts of equity, i.e., divorce courts kinds of things, where judges are deciding what to do, what's the best thing to do. You have to come with, if you're saying, hey, court, please do this because the other side's being mean and nasty to me, you have to come with clean hands. You can't say, well, yeah, I did all these bad things and they did all these bad things too, but only punish them. So that's why the divorce stuff, you just have to, it's just ugly. So I'm not going to go near that Sophie case. I just don't think that it's, let's see, Mary Lopez. Good question. Letitia Stout, can she keep getting psych evaluations? Is it going to be unlimited? Oh my gosh. My microphone just came undone. But that's all right. The show will go on. Guess I moved it too much. Letitia Stout, can she continue to have more and more competency evaluations that they'll go on for years? And the reason we brought that up is we talked about the case today where the guy's case had gone on for 6 years. And part of that was because he spent a couple of years being restored back to competency. So Letitia Stout, obviously, I go back and look at the record here, but she's been evaluated for several months now. Then competency evaluation comes back. Defense says, no, we want another opinion. Send her back off again. Take another couple of months. Then we have to have a hearing. If the defense says, yeah, we're not contesting it, then it's okay. Game on. Let's get the game rolling again here. We're still at preliminary hearing stage. However, if they say, no, we think that if there's an issue regarding the competency, then we have to have a hearing. Well, let's schedule it. Then you got to schedule all the doctors with their schedules as well. And so this could go on for months and months and months. And if she is found to ultimately be found to be incompetent, they have to send her back. And I've had cases where clients have been deemed to be incompetent. You think they get them restored, you're moving forward, and then you find out, oops, they're not taking their medications, and we're right back where we started again. You can raise competency. You can raise competency at any state, even in the middle of trial, if it's if it's an issue. The attorney you have to have a good faith basis for it. You can't just do it to stall in due time. You just can't do that. Yeah. Estella, that's right. Frank, he came through. Imagine if I was doing this by myself, I'd be here holding the microphone, Thanks, Frank. I appreciate it. Nice catch. That's right. That's wow. It was like, wow. Let's see here. There was something about the Letitia Stout case, and Letitia Stout case is interesting. Oh, here's Brian. How often are people deemed incompetent? I don't know off the top of my head, but it happens more frequently than people could probably think about. I wish I had some good numbers. I don't off the top of my head. And you know who has really good numbers on something like that? Usually the Office of the Public Defender. Why? Guess what? Many of the people that have mental health issues, obviously, are usually having a very difficult time in life sometimes. Don't want to make generalizations, but, um, if they're homeless, if they have drug and alcohol issues, very possibly they're going to be represented by the public defender's office. A lot of times you see people come in that are represented by the public defender's office. Uh, they're homeless. They're living on the streets. They have drug, alcohol, and mental health issues. And so they're the ones that are going to see that the most. And sometimes it's simply the case of, the people know that they have to take the medication, but they cannot afford them. And so they stop taking their medication, and then all the bad stuff that starts happening again. I remember it wasn't my case, but I remember I was sitting in court one day and there was a gentleman there. He had been released from parole and he had medication. I think it was for schizophrenia. And when he got released, they gave him enough medication for 30 days to get his medication. And the judge, said, I don't understand this. We have this man here on a parole violation. We're going to send him back. And I think he had a new charge as well. But when he's on his medications, he does fine. He ran out of his medications. We're right back here we are again. So why can't we come up with a way to make sure that this man's medication, which is under $100 a month, be taken care of? Because the alternative is I have to send him to prison, and I'm going to have to spend, or the state's going to have to spend, between $28,000 to $32,000 per person to house somebody, when we could generally solve the problem for $100 a month. Now, it's stuff like that that just baffles the mind, that people cannot come up with a good solution like that. So we'll see. Glowing Embers, Scott, do attorneys in the same law firm confer with each other regarding cases? Yes. We have my office here. If you count me, we have five attorneys. We talk about cases all the time. In fact, most of us work on the cases. And so, yes, that happens all the time. Now, I think what the question you're getting at there, Glowing Embers, is the fact that Means and Vallow, Mark Means, Lori Vallow's attorney, and Mr. Pryor, Chad DeBell's attorney, share office space in the same office suite. There's nothing unethical about doing that, and they probably are conferring quite a bit about cases. Frankly, it's a lot easier. If you're going to have a co-defense case, you might as well have somebody across the hall. You kind of keep your eye on what's going on, so to speak. But obviously, they cannot reveal attorney confidences unless it's been disclosed. No indication whether there's been a joint defense agreement in this particular case, but we'll have to see. We'll just have to see. So yeah, it's not a conflict. And I remember, I had office sharing situations over the years, and I rented out, an office space, and somebody would come in and say, "Hey, I've got a case, and so does my wife or my co-defendant. Can you represent both of us?" "No, I can't do that. But hold on a second. Let me run down the hall and let me get you an attorney." And nothing wrong with that. You still owe your duty of loyalty to your client. And you have to be cautious about, what's can be seen by the other attorney. But the reality of it is you're usually trying to work for a common goal at that point anyway, but it's not nothing unethical about that anyway. Let's see here. Some people are functional as well. Let's see here. If they are indeed legally married, would they be able to testify against each other if they desired? All right, Brian Forrester, switching back to Lori and Chad. If they are indeed legally married, would they be able to testify against one another if they desired, or are they legally unable to do so? Normally, in cases of abuse regarding children in the household, marital privilege does not apply. Additionally, marital privilege only applies while you're married. So statements done pre-marriage are not protected, even if you have that privilege. Most states have gotten away with the marital privilege as it relates to any kind of abuse of children. I believe we actually looked that up and read that in one of our previous shows as it related to that. So, yeah, I don't think marital privilege is going to be an issue anyway whatsoever. Why do you think Means and Pryor are using such different strategies? I personally think that Pryor, like I said, I think he's much more experienced, much more sophisticated criminal defense attorney. And I think Means is trying to figure out a way to ride Pryor's coattails through trial. That's my honest assessment of that. Let's see. Since the rest of classes go back to the court every few months. Let's see. The only have to act like they don't understand the charges against them or the court process, then somewhere else to have classes go back court every few months for another competency hearing. That's a question from Lisa. Not necessarily, Lisa. The standard for competency is actually pretty darn low. Now, I think that Letitia Stout is completely competent. I believe that, although we haven't seen the competency report, that it will be confirmed in the second report. Yes, for one to be competent, you have to be able to understand the roles of the parties in the courtroom. What role does the prosecutor play? What role does the defense attorney play? What role about the court? Do you understand the rights that you have in the courtroom? Now, it's not just say, I don't know what my rights are, because frankly, most people don't know what their rights are when somebody goes to the courtroom, particularly even themselves. But they have to be able to understand that they have a right to assist in their defense, to be able to call witnesses on their own behalf, to testify, to not testify, that they have a right to an appeal to a higher court, that if they don't testify, the jury would instruct the jury, if they so requested, that they could not use their silence against them. You have to understand, what happens, what are the consequences. They don't have to understand every element of the charge in the sense of, gee, what are all the legal definitions? But they have to be able to understand, why am I here in this courtroom? I just don't know what's going on. Usually there's a mental illness. Mental illness doesn't necessarily just rear its ugly head. And, when you're say that you can write letters to the court saying, hey, I was working on my PhD in education. I'd really like to get back to that, but these charges are really hanging up my plans here. So can we get this moving along so we can get out of here? Because it's just a big misunderstanding. Probably not going to come back as not competent. She's writing letters to the judges explaining, that what she wants to do in the future. I'm not saying it's delay. I mean, I've never met Miss Letitia Stout. Her attorneys have, although it appears to be somewhat limited based upon her letters to the court because they haven't been able to go to the jail to see them because of COVID. So who knows? I think she'll come back competent. I think the next report will probably come back that she is competent to proceed. And then when you have two strikes against you like that, you're not going to request a third. And if that's the case, the public defender better go get their own psychiatrist, say, hey, I've interviewed this individual and she is not competent to proceed. So, and some people, if they are in fact found not competent to proceed, are never going to get better. Right? We want people, we don't want to just send people off to prison or to punish them unless they understand the proceedings against them. It's called due process of law. And, you say, well, they're guilty. They're just, no, we can't do that. Okay. That's fine. As long as it's not you or your family member, your close friend, you have rights. We have to do that. Let's see. Can't the prosecution withhold information or evidence of murder until investigation complete and ready to charge someone? We may not have the details that the police have, like the autopsy reports. Susan, yes, you are right. But this case is so intertwined as it relates to the current charges against Chad and Lori Vallow at this point that evidence is so intertwined, interrelated with these charges that the prosecution would more than likely have to turn over that information in the discovery. So there's always a chance, but I wouldn't get too excited about it. We'll just have to wait and see. And then charge them for the next county or Chad and Lori. T. Polling. I hope that they can stack the charges up. Charge them in one county for this, then charge them for this in the next county on Chad and Lori. Well, obviously, if that's the case, let's see if they get through this trial, and who knows, maybe there'll be murder charges coming. But if I was the attorney for Chad or Lori, if in fact they were ever charged with it, I would be jumping up and down, and I would be arguing for compulsory joinder. Hey, you guys were doing this investigation. You knew my client had this. You can't piecemeal this case together. You had your shot. You blew it. You should have brought your murder charges when this case was going on. And, the DA's got to be worrying about that. I mean, they should be maybe not worrying about it, but they should be thinking about it. Because the reality of it is that, we don't piecemeal cases against people. Oh, you're done with that case? Oh, yeah. You have all these cases. You have to kind of bring them. You can't piecemeal them. Oh, you're done with this case? Okay, now we got this other case. We've been lying in wait to see how that turned out for you. Ooh, sorry about that. And in this particular case, the authorities are all working together. They're aware of it. The DA is aware of it. And so if they're going to charge murder, they need to get around to it. Otherwise, I think it's going to be difficult, and there'll be some issues that are coming up in the future that may make it more difficult to do that. So my thinking is the prosecutors got the evidence, charge it, bring it on. If they don't, guess what? We'll just have to wait and see. Bottom line, we'll just have to wait and see. All right, ladies and gentlemen. Hey, want to ask you all to go to crimetalksearch.com, sign up for this background subscription. I am telling you, we ran background searches on all the witnesses in the hearing that we did yesterday, and you just never know what will come up in somebody's background. I'm telling you, yeah, you get a background, criminal history of all the witnesses by the prosecution, right before the trial begins, but that's it. But why would you wait for the prosecution? You do it yourself. We did it, and guess what? We found some really good stuff, and we use the exact same thing that I tell you all to go sign up for. So go to crimetalksearch.com and sign up. I'm telling you, when you do a background search on people that maybe you want to get to know, maybe people you no longer want to be a part of their life with, you'd be amazed what people have. There's so many people out there that have a hidden life. You would not believe it. It's one of the 12 fundamental principles of life that I talk about in that video. One of these days I have to update that, but literally everyone has something going on in their life, their background, and they probably don't want to talk about it. We've had so many people that have come forward with stories and information about, hey, I was getting ready to date this guy and found out he had charges of, children against him. Other one, I was getting my business partner, found out he had fraud charges. So just go do it. Oh yeah, love fraud. Oh yeah, let me tell you. Love fraud. That's it on Netflix. If you do that, if you watch that show, we're talking about this con guy. Oh my God, love fraud. I'm telling you, some of these Netflix cases are the best. It's a case about this guy, Rick Scott Smith. And it's a documentary put together regarding this guy and his exploits, literally over the last 20 years, I think, about how this guy basically befriends women. Oh, by the way, and then steals all their money and then literally packs up and leaves one day. And it's not like he's dating super rich women and he, takes them for, no, we're talking about everyday working class people. And he comes in and just woos them and kind of wines them and dines them and is just bad guy. Anyway, they find him and track him down. I think there's one episode left I haven't seen, but I'm telling you, you have any reason to doubt, getting a background subscription service, go watch Love Fraud. And I'm telling you, you will do a background search on anyone you ever meet or date in your life. So it's crazy. So go to crimetalksearch.com. I'm telling you, you will be happy you did. And I'm telling you, if we didn't use this stuff, I wouldn't be promoting it. I assure you. All right, let's see. Tiffany, he was asked before. He says it is your constitution, the privilege between clergy and their congregation. Isn't it great the government can't ruin that privacy like attorney-client privilege? Yeah, I'm not sure there. Let's see. Working together, are they playing chicken on the joinder? Ooh, looks like we lost something here. I'm back on? Okay. All right. So yeah, yes, they need to be, kind of working together, so to speak, but there's clearly they got to do what's best for their own clients. And the reality of it is, I just think that Means is doing a much, much better job. All right, ladies and gentlemen, we are at the top of the hour. We actually went a little long. Thanks for tuning in. Thanks for watching us. Do truly appreciate you doing that. We know that your time is valuable. So the fact that you watch us, we greatly appreciate it. But if you haven't done so already, hey, go to the link below. I think you got to go past the little things at the bottom, but it's for Patreon. You can sign up. Frank, the hardest working man in show business, will then send you a link and we can continue the conversation, talk about what you want. We'll take your questions, but more importantly, we will take your calls. You can call in and talk. And let's say, if you disagree with me, we'll take you first. But we got this fancy system where you can call in. I think we have like 10 people queued up. So please call in. All right. That's all we have for tonight. Thanks for watching. And we'll see you tomorrow when we put out another video. Have a great day. And thanks for watching Crime